dismissed because all that case dealt with was a woman who was employed said that my boss is on a sexual offender list. They fire her and they say, listen, this sex offender list has nothing to do with your job.
Her employment, right?
Yeah, your employment.
No nexus.
Dr. Price, this is all she did. This statute, 273, and the Urban League keeps telling you, Your Honor, that the courts have never found a cause of action here. They've never not found a cause of action. And that's what the Marshall opinion actually shows. A proper reading of the Marshall opinion delves into all the ways the courts have found causes of action. Okay, Dr. Price's position as an officer, Your Honor, is only and inherently her employment. That's all her being an officer, the CEO of the Urban League dealt with. All she did as an officer was work for the Urban League. When she saw that the Urban League wasn't properly reporting its finances, that was pursuant to her job. When she said that the Urban League has funds that have gone missing, that she learned and actually rose as an officer in her job. Every single thing in her complaint had to do with her job. Now, this case, Your Honor, this case, you would be 100% upheld and have the full backing of the Courts of Appeals and the Supreme Court if you denied this motion. It's straightforward and it's simple. Officers. I don't know why the Urban League is moving the goalposts on what the framework of wrongful termination claims are. But when Dr. Price has a position and she has statutory obligations as an officer of a nonprofit, nonprofits have a lot of protections, lots of protections with the way that they have money, with the way that they're seen in the community, with the way they're seen in the law, with the way they're seen in taxes. With all of those protections, there are obligations. Statutory Kentucky obligations for an officer as an employee of the Urban League. When Dr. Price was trying to fulfill her obligations, that's when they fired her in direct response.
Someone else, obviously, that she thought that this money had been, allotted erroneously or gone missing, or she mentioned it, and then they terminated her like days before the board meeting.
Yes.
I read through this, but it was this morning, and also wrote another order, and so my head is a little. So, but that's. It's not in the complaint, Your Honor. There is nothing which purports to be fraudulent by any action of the league. Not only because it didn't happen, but because it's not in the complaint. What it is that the league has done that is allegedly illegal. The law also requires, Your Honor, for the league, under the Welsh versus Phoenix transportation case, for the league to affirmatively ask, violate the law or do something that's unlawful. She did not allege that. Not only did it never happen, but it is not in the complaint standard in Kentucky. However, the plaintiff failed to meet it because she cannot, because it never happened. So the Smith case exists as it relates to the statutes, which Dr. Price cited, involves the business judgment rule. It has nothing to do with wrongful discharge pursuant to public policy. It's a narrow exception, and Your Honor, we take exception with the multiple allegations that were made today. There was nothing to be thwarted, but regardless, most of these things were never actually alleged in the complaint, despite today's allegations. Your Honor, we urge the court to grant the league's motion. There's no cause of action, the plaintiff has failed to state one, and this is precisely why the law exists. Your Honor, any court would affirm it because this is an expansive reading. Denying the motion to dismiss would be an expansive reading of the narrow public policy exception, which is well established in Kentucky law. Her case must be dismissed. I feel like either way I rule, it's going to go upstairs anyway.
You might address a couple last things, Your Honor.
Of course.
The only thing, briefly, Your Honor, number one, Dr. Price never cites the word feelings anywhere in her complaint. This is not about her feelings. This is about her getting fired for her job. She was fired because she was trying to be ethical. She was fired because she was trying to be honest. That's why she was fired. That's why there's a cause of action. And what the Kentucky Supreme Court has said in the Russell opinion, which is the most fresh opinion there is, they can talk about Mitchell all day. They can talk about Marshall all day. Russell versus Johnson Johnson is subsequent to that, and it deals with Rule 12. Don't look for a flaw. So if their apparatus, if their basis today is no court has ever had a case, no court has ever upheld an employment case based on this statute, no court's ever denied it either. And that's what courts are encouraging you to do. Don't look for a flaw. Look for cases to proceed. That's what the Kentucky Supreme Court's encouraging you to do. Look for cases to survive. Very important in this community, Your Honor, in any community, when you have nonprofits, and you have money, and you have donations, and you have goodwill, places like the Urban League are granted a lot of deference, but it comes at a price. You can't fire Dr. Price because she's trying to do the right thing. You can't do that. And you're absolutely right, Your Honor. They've never articulated why they fired her after 4 months. Your Honor, again, if you're gonna look, and if they're gonna have that as the basis, like, hey, no court has ever upheld this. No court ever upheld something until its first time. If you look at Marshall, and they go through all the cases in Marshall, they give you a whole expose. Every single one of those was the first time. This case is inherently about her employment. That's all her relationship with the Urban League is. Dr. Price was an employee. Every single thing in her complaint deals with her employment. You're gonna get upheld, Your Honor, when you deny the motion.
Okay. Is that all? No? You're still gonna? If Your Honor will indulge.
Very briefly, I don't have.
Very briefly.
Okay.
The reason for Dr. Price's separation is immaterial. It doesn't salvage or state her claim. What has happened here is employers have the right to exercise their judgment with respect to making employment decisions. Here, this action, this lawsuit has detracted and thwarted from the League's critical and very important mission and value in our community. It's a shame, Your Honor, that you have had to spend your time and the court's resources on this case. The motion must be granted. There is not only no basis for this complaint to proceed, but it would be detrimental to the League's work in the community and all of the people it serves. Thank you, Your Honor.
Okay. Well, that's part of my job. That's why I'm here, and that's why my staff attorney's here as well. We're gonna dig through all of this case law and look at the statutory scheme, and I've read through the briefs. But okay, we will look at this. Is there anything else?
None for me, Your Honor. Thank you.
Okay. Yep. All right. Get off the record. Thank you both.
Thank you, Your Honor.
If you do nothing else,
If you do nothing else.
Do nothing else.
If you do nothing else,
If you do nothing else.
If you do nothing else.
If you do nothing else.
Stay live.